Good morning, and thank you for joining us on this snowy Washington, D.C. morning. We have about an inch of snow and ice here on the ground in Bethesda, and apparently more expected throughout the day. We hope everyone is in a safe, warm location this morning. I'm Kevin Fitzpatrick, CEO of the Government Technology Insurance Company, partner at the Capital Group, and your host for the next 60 minutes. We provide healthcare, commercial insurance, and 401k strategies to the Washington, D.C. business community. To say we have a lot to cover today would be an understatement, so we'll dig right in. We're going to be discussing employer liability in regards to COVID-19, bringing employees safely back to work while simultaneously protecting your business interests. Our panel of experts is going to discuss how new government executive orders and laws will impact and guide your policies, what type of accommodations you may need to make for employees, and understanding the risk calculus for possible liability. We're also going to review Biden's 4-point plan for essential workers, mask wearing in the workplace, the recently released January 29th OSHA COVID guidelines, and last but not least, what states are requiring COVID-19 and mandatory preparedness plans. We understand this is currently a very fluid situation, and probably about an hour after this program is finished, additional information will have inevitably bubbled to the surface. However, our legal and compliance departments, alongside our strategic partners, are ready to help you with your questions, provide guidance and strategic advice all throughout the balance of the pandemic. Please don't hesitate to reach out. With that, I'd like to welcome our panel of experts. Today we have Andrew Beardall, in-house general counsel at the Capital Group and COO of the Government Technology Insurance Company. Andrew is a graduate of the law school at Catholic University and holds a graduate degree in molecular biology. Kathy Goyne, CEO of OpsPro. OpsPro is a GovCon-focused service provider for back-end office and operational support. Kathy's company offers a wide range of services from on-demand consulting through full outsourcing of all operational processes. She's one of the best in the GovCon field, and we're thrilled to have her here today with us. Seth Barentswig is the managing partner at Barentswig Leonard Law Firm, has extensive experience in corporate and business law, including litigation, both inside and outside of the GovCon arena. Seth makes regular guest appearances on Fox News, CNN, and CNBC, and is a longtime Capital Group strategic partner. We're glad he's able to join us for today's discussion. We encourage everyone to please submit your questions throughout the program. I'll be monitoring them on our YouTube channel here. We're going to try and get to as many of them as possible. If we don't get to your questions, please feel free to contact us post-program, and I promise you we'll do our very best to answer it. Our contact information will be posted. The program is going to be recorded, and we're going to send it out to everybody for future reference. So we have a lot of information to share. But without further delay, I'd like to turn it over to Andrew Beardall. Andrew, take it away.
Terrific. Thank you, Kevin. I appreciate it. Welcome, everybody. First, one small correction to Kevin. My degree is in neuroscience, not molecular biology. But that's okay. So there are a lot of changes going on right now. The vaccine is coming out. We have a new administration. People are going through coronavirus fatigue. And because of all of those, it's impacting the workplace. Now, the last thing you as a manager, as an owner of a company want to do is try to slap together some type of return to work policy. Because there are so many moving parts right now and so many different things going on. If you do not take the time to plan in advance and create a return to work procedure, you will doubtlessly get caught in making mistakes, making errors that could potentially open you up to liability. Now, what we're going to be doing here today, my colleagues and I are going to be going into the weeds on some of the details on vaccines, on executive orders, and different things that will impact a workplace. But you have to keep in mind that this is an overview. And as Kevin said, these things are changing all the time. Or maybe you have state and local rules that will impact you. So I strongly encourage you, when you get into the details, reach out to professionals, reach out to your lawyers, reach out to your HR consultants, reach out to your insurance folks, reach out to any of the three of us. We are happy to help you out on these things because the goal is to get this done right. So I'm just going to talk about ownership and management here for a minute, and just a few things to keep in mind over the course of this presentation. One of the first things you got to do is really examine what are your requirements going to be for the rest of the year. Are you going to let people keep working from home? Will your clients let you do so? If so, you may not need to do a lot, and you can start watching cat videos instead of this presentation, because if it isn't broken, you don't need to fix it. But if you are talking about returning to the office, there are things that you're going to have to take into consideration. How are you going to modify schedules? Do you have to move desks around so you have appropriate separation? What's the state requiring you to do? What are the feds requiring you to do? Are you going to put up plexiglass between people to help them feel safer? Are you going to be giving everybody masks? These are questions that you as management have to consider and should have a plan for as part of your return to work rollout. And then if you're returning to client sites, what are the work site rules there? Have you asked your clients for information on what they're going to require? And of course, the elephant in the room is vaccinations. Mandate to vaccinate. That's the title of this. And Seth is going to go into that in just another minute here. But how are you going to implement that? Now, once you've considered these things, you have decisions to make as the management here. How are you going to roll out your return to work? Who is going to make sure that the compliance is there with government orders, state mandates and laws and the like? What kind of accommodations are you willing to make? And how do those conflict with business realities? And how are you going to communicate this to the employees? It's probably the most important part, because it really is, how do you get this message out to your team? Because you're going to have some difficult employees, and you're also going to have to figure out how to deal with them when it comes to somebody who doesn't want to get vaccinated, or is perfectly capable of showing up at the office but is just scared to. How will you address those? And what is the risk that's going to be out there for your company between employees, the government, and your clientele? So I just want you to keep those points in mind as we dive down into the tall weeds with Seth and Kathy here. And I'm going to pass the buck to Seth right away, and he's going to be talking about vaccinations. Seth?
Thanks very much. Good morning, everybody. I'm Seth Berensweig. I'm the founding and managing partner of Berensweig Leonard. We're a business law firm headquartered in Tysons, and it's a pleasure to be here. We're talking about really a new age, and part of the difficulty of managing the rules with respect to pulling out of the midst of the coronavirus is that the nature of corporate management and HR and employment law was completely different before early 2020. The rules only about a year ago, which for purposes of today we can call the old rules, were based on the assumption that, so sometimes as the phrase that we would use it, HR management wouldn't play doctor. In other words, the company management would not get proactively involved with respect to someone's course of medical care. And it wasn't really something that was on anybody's radar screen. This is, as they say, the once in a century event. When COVID struck and was becoming very prevalent in the midst of last year and through the latter part of 2020, confusion still reigned in terms of how to be able to turn the lights back on and bring back the workforce, because we didn't yet have the vaccine. We still were working on many decades worth of HR principles and precedent that said that we don't play doctor and we don't get involved in people's vaccinations. And frankly, as late as the latter part of 2020, the federal government, including the EEOC, provided no specific substantive guidance on how to be able to deploy vaccines once it became clear that there were some vaccination options. Finally, in approximately the January timeframe, the federal government provided some guidance. And basically, although it really wasn't very clear, we can really bottom line for you what the rules are today. And this is really boiling everything down, which unfortunately the federal government, up until the last couple of weeks, really hasn't even provided a very cogent, clear path on. The bottom line is that employers are able to exercise their authority to require a vaccination as a precondition for return to work in the office. The company has the authority to do that. And there's been a lot of controversy to that because the workforce they're very wary and unfamiliar with the vaccine. It's been put out through an emergency use authorization. Fortunately, the current vaccinations, aside from the J&J option, which will hopefully be approved in a few days, does provide an efficacy rate of about 95%. But as the employer, the company has the authority and the legal power to be able to require vaccination as a precondition for return to work. Now, there are exceptions, and the exceptions to that general rule have also been getting attention in the media. The one thing I need to emphasize is that these two exceptions are extremely narrow. There is a disability exemption and there's a religious exemption. The disability exemption under the Americans with Disabilities Act provides that if the implementing the vaccine would somehow interfere with or cause some kind of a disability, then that would be an exemption. Also, if there's a religious objection, then that is also an exemption, although frankly, I think that's even narrower than the first one. But even if there are objections to an employee and they're trying to assert one of these exemptions, I think that there are a couple of characteristics that I've seen over the course of time. First of all, most employees don't know what those exemptions are. They really express a general anxiety and uncertainty with regard to the vaccine that is not a protected exemption. Secondly, if somebody comes in to management and asserts one of those objections, the company needs to require some kind of specificity and demonstration of how that employee is trying to apply those exemptions. So for example, if there's some kind of a health-related disability objection, it's valid, for example, to require that there be some kind of medical documentation, such as a doctor's note. These can get pretty thorny, but again, I think that there's going to be very narrow exemptions. The vast majority of people that are going to be objecting to this are not going to fall under those exceptions. But of course, if they do come up, or even in the midst of trying to launch this, you should definitely consult with your employment law counsel. Communication, of course, is key. We want to be able, as companies, to apply this leverage, but we need to do it in a soft and gentle way to let people know that we care about their health, we care about their welfare. We're pleased that this is giving them the opportunity to avoid becoming ill, and also coming in the office and perhaps making somebody else in the office place ill. So it needs to be done very carefully. But certainly it's important that the company be aware of the status of the law in this regard. The company has to be very careful to keep in mind that it should try to maintain communications and any medical interactions with its employees in a confidential manner, and that it not engage in any kind of retaliatory reaction. The company culture, of course, is not going to be fostering that. But if you have mid-level managers, you're going to need to let them know what the rules are so that they know how to navigate this. There has been some movement in the news lately about companies adopting what are called vaccination incentive plans, just a way to diplomatically nudge people into getting those, covering all costs, providing 2 hours worth of additional leave to make sure that if somebody takes time off to get the vaccine, that they don't get dock pay, something to be able to create a moderate and reasonable incentive for people to get vaccinated. That's something that we've seen be quite successful. There are a couple of other issues that come up under the mandate to vaccinate issue. The company says, well, what are some of the other tangential liability issues here? So let's say, for example, the company says to someone who's reluctant, get the vaccine. and they say, okay, fine, I'll do it. I don't want to do it, but I'll go ahead and I'll take the vaccine because it's a requirement to keep my job. If they incur any kind of a long-term disability as a result of the vaccine, which is extremely, extremely rare and not expected, is the company potentially liable for any damages as a result of that? And the answer is probably no. The company, in acting in that manner, is going to be acting in accordance with CDC guidelines. In order to be able to demonstrate that the company has any kind of liability for that requirement, the employee would have to meet some kind of a basic standard of negligence. And if the company rolls it out appropriately, that negligence standard is not going to be met. Conversely, if the company is not careful and doesn't maintain a safe work environment, it may have implications as far as running counter to OSHA regulatory requirements in terms of maintaining a safe and healthy work environment. Some employees who have concerns with regard to related health issues might inquire as to whether there are any rights for them under state law. They may have some rights under workers' compensation, but that's a local issue and something that is really more predominantly an issue for the employee. So this is obviously a very active and very dominant issue moving forward as we go to the conclusion of the coronavirus and as we hopefully turn the corner in this summer. And if there are any issues or questions, then it can certainly be raised here afterward. Since we're limited on time, I just wanted to move briefly on to the issue with respect to the WARN Act. Under the Federal Worker Adjustment and Retraining Notification Act, the so-called WARN Act, employees with 100 or more employees must provide advance notice to employees when either permanently closing a location or when implementing what is referred to as mass layoffs. More specifically, covered employers must provide at least 60 days advance written notice of a closing or mass layoff affecting 50 or more employees at a single site of employment. So it pertains to employees with 100 or more employees in a closing or layoff affecting 50 or more employees at a single site. It would include layoffs. It's also important to keep in mind that this would include significant reduction in hours. So it may also trigger a WARN Act requirement when you have a reduction of hours for 50 or more full-time workers by more than 50% of their time at any time frame within a 6-month period. The reason where this comes up in COVID is that if you have a COVID forced shutdown of an offsite location, you may have a WARN Act violation. If you also have a situation where you need to have a rotational presence of employees, but it has a reduction in a majority of their hours, that may also trigger a WARN Act violation. This is something just to simply keep in mind because the WARN Act is not a very popular, sexy issue, but it might become a very sexy issue, unfortunately, if it's something that you have to deal with. Be aware that there are states that have many WARN Act requirements, some of which may be stringent. The courts have said that COVID-19 generally is not considered a sudden natural disaster or unforeseen event that would provide an exemption to a WARN Act requirement. So therefore, the courts have really looked at this issue as it relates to government contractors, and that's something that you need to be aware of. Another instance where this comes up for government contractors is where somebody is an incumbent on a bid. And they are not yet certain as to the final determination of the government. If you believe that you're going to be rolling off a site potentially because of the event that you are not successful in the reprocurement, just keep in mind that the WARN Act may apply. And you also have to be aware of potential misclassification issues because in order to have the 50 or more employee threshold, that standard doesn't care if you mischaracterize 1099 consultants rather than actually being treated as employees. So as you can see, government contractors have a variety of issues as it relates to management of the workforce. And I know that we're running through this quite quickly today, but these are certainly very important guideposts to keep in mind as you move forward in 2021. At this point, it's my pleasure to now kick this off to my colleague, Kathy.
Thanks, Seth. I appreciate it. That was definitely a lot to keep in mind. And a lot of the pieces that you were talking about are also going to correlate with some of the stuff we're going to discuss in Biden's new executive orders. So we're going to go over a couple of topics. The first one is protecting the health and safety of the workers, economic relief as it's related to COVID pandemic for workers, essential workers, mask wearing mandates, access to federal buildings during this time as a government contractor, and also highlighting some state requirements for COVID. So probably the most important piece that I want to make sure that folks are aware of, and I will make sure that the link is included in the comments of the YouTube posting, is that on January 29th, OSHA, we put out some new regulations on what is considered workplace safety and COVID. And you want to make sure that you are aware of those. It's going to cover everything from mask wearing mandates to the amount of space between desks to reporting requirements. One of the first things to realize is that if you have an employee and you're a government contractor, OSHA applies to you. So it's the reporting of health and safety for your workers. There's also going to be additional guidance issued on March 15th about mask wearing. So they'll probably get a little bit more into the details there along some of that sort of stuff. They're also going to launch an enforcement program. So something you want to keep in mind is if you're not following all the rules and regulations that they have put in these guidelines that they've issued, you can start having employees report you for a lack of safety. And they're talking about it's going to be $1,000 per occurrence per work site per person if you're not following the required guidelines. So that can get very expensive rather quickly. And they're going to launch an enforcement group. So just keep that in mind. The next piece we want to sort of talk about is the economic relief. So President Biden has asked the Department of Labor to consider, not done yet, but to consider clarifying workers that refuse employment because of their health or health of family members to be able to continue to qualify for unemployment insurance. We're not quite sure yet how that's going to affect because unemployment is really a state-by-state piece. So we want to make sure that as they roll through these decisions, you not only look at it as a federal level, but also on a state level. But your employees might start having rights to turn down work and still receive unemployment if they fall in the buckets of high risk for illness. President Biden has also issued a 4-point plan for essential workers. And this is to make sure that, one, all essential workers have access to protective PEE equipment and COVID testing based on their risk to the exposure, as well as childcare assistance. And other forms of emergency COVID support. He wants to expand access to the protective equipment. He wants to be able to establish and enforce health and safety for the workplace. And then also something to keep in mind, especially as we start rolling into the BD season and you're going to start bidding on new government work, or if you have a current contract that allows for a clause of pricing adjustments due to changes in the contract, he's advising that he wants to enact premium pay for frontline workers that are willing to put themselves at risk. So that's at a federal level. Right now, there happens to be a bill proposed in Maryland, which would even supersede this. So if you're an essential worker in Maryland, they're talking about that you would have to have an emergency preparedness plan for health in case you had a massive COVID outbreak. You would have to report all cases to the Department of Health in Maryland. You would have to provide paid leave for emergency-related reasons, including bereavement if somebody in their family passed away, and up to 13 days of health leave paid if they're ill. You would have to pay hazardous duty pay of no less than $3 per hour per pay during the emergency. And then you would also have to assist with healthcare costs with employees that don't have healthcare coverage. Now, this is still being negotiated, and this is just a bill on the floor of Maryland, but this is an example of some of the stuff that people are starting to talk about to help employees. And obviously, these are costs that you haven't even begun to think about and how you roll that into your pricing and your benefits to your employees. When thinking about all of this, there's a couple pieces that you want to make sure from an HR regulation you're doing. First, OSHA applicable. Well, as we said, if you're a government contractor and have one employee, it matters to you. So everything we just sort of talked about. You need to determine if you have essential workers. That can be a state-by-state definition. So most of your state's Department of Health or their labor sites will advise you what they're defining essential workers to be. You want to make sure that you keep an eye on any superseding state laws above what Biden is talking about in his platform. If your employees are remote, then the majority of what we just talked about there is not going to apply to you. If you can keep your people working telecommuting from home, you don't have to worry about the hazardous pay. You don't have to worry about providing the PPE equipment. You don't have to worry about all these sort of other pieces. And then we talked about the fact that they are doing a fine-based thing. If the employee calls in to complain that they feel like they're unsafe, you could be looking at some significant fines going forward. The next thing we want to talk about is the mask wearing mandate. And this is going to be very similar to what Seth was talking about with the vaccine. So Biden has advised that federal contractors that are on site in federal buildings must comply with the CDC guidelines of wearing masks, maintaining physical distance, and any other requirements put in place by that facility. There can be case-by-case exceptions as required by law to accommodate for disability or for religious reasons. But we also want to make sure that you have stuff in place to protect you as an employer. So you need to have a mask mandate policy written, and you need to have it signed off by all your employees so they understand what the requirements are. And if you have some employees who are saying that they can't do so because of medical, you want to make sure that you're differentiating between a want and a need. Not wanting to wear a mask is going to be very different to I can't wear a mask because I have medical needs. And then at that point in time, you're going to have to go down, as Seth talked about, like the ACA guidelines and other things. If an employee refuses to wear a mask and they don't fit into those very small windows Seth was talking about, the employee can be terminated for not following the policies and procedures on the client site. But you're going to definitely want to go through what is your normal HR process, right? You're going to want to do a discussion. You're going to want to write it up. You're going to want to tell them they have to wear the mask, so on and so forth. And then you can move into a termination. The other thing you want to really make sure is if you are putting this plan in place and you are requiring these things, that is applied fairly. So if your worst worker doesn't wear the mask and you terminate them, and your best worker doesn't wear the mask, you're also terminating them. You can't differentiate based on the value of the employee to you. Access to federal buildings will continue to be limited, and they may continue to even make it more so depending on how everything goes through the vaccination process. Allowing your employees to work from home, you want to make sure that you have a telecommunication policy in place and that they've signed off on it. You want to make sure the employee is aware of what their core hour requirements are to be, what your expectation of work volume and response time is, what your expectation is if all of a sudden they lose internet or phone service, these sort of things, so that if you have an employee that likes to consistently say, well, gee, I'm so sorry, my power went out, I couldn't work today, my power went out, I couldn't work today, or nothing's getting delivered in their work, you want to have something that you've already set the expectations so that if you move down the process pipeline of terminating or putting them on a performance improvement plan, you have already advised them what the company policy is as it relates to telecommunicating. If you don't have a policy and the employee has not signed off on it, you cannot hold them accountable for any of the problems you're having. If you deny the ability for the employee to work from home, the employee can still seek paid leave under the FFCRA until March 31st. After March 31st, the employer no longer has to provide paid leave. You may choose to do so because it's in the best interest of you and your company. So when we're talking about the access to buildings and the working from home, some of the things you want to make sure that you're checking on and you're following through on is first check with your contracting officer for your contract, determine the feasibility of being able to work from home, ensure that you have your telecommunications agreements signed with your employees and everybody's understanding of the requirements of working from home. Again, your human resources folks, we need to keep an eye on the administration's changes as well as any superseding state laws. And if you're in 5 states, that means 5 different states. Of course, we all know there's several states that typically lead the way. So California, New York, Pennsylvania occasionally, depending on the rules and regulations. So, those are the ones I would definitely keep a heavy eye on, because they typically lead the way in employer-based laws that favor the employee. And then you can, as we talked about, considering the paid leave for employees if it makes life a little easier for you. And I think if we can go to the slide deck with the map, we just want to talk real quickly. So there are states that require COVID planning and states that require COVID training. So right now you can see a map up there that shows the states that require COVID-19 training programs with your staff. There's either required, suggested, or not applicable. This is something you're going to want to be aware of. Again, back to checking those boxes about liability from the employer. If your state has a mandated training program and you have not implemented it, and then you bring your employees back and there's an outbreak, and then you haven't been following the OSHA requirements that have been listed, you're just compounding a problem after a problem after a problem. And then there's also states that require a training program, and then as well as, Rob, you can go to the next slide for me. Thank you. A preparedness plan problem. So this is the a preparedness plan. So this is the same concept, but instead of training, you have a plan available. Now, the recent OSHA regulations or guidelines that posted out say that they're moving this way to a federal level. So I'm expecting at a federal level that everybody will have to have a preparedness plan. So that is, you have 100 people in the office, one person tests positive for COVID on day 1, on day 3 you've got 3, on day 5 you got 12, on day 16 all of a sudden you have 100 people, and all those people went out into the workplace. So how are you preventing it from going to 3 people to 100 people? Where are you reporting it? What are the things in place? What are your cleaning procedures? How are you notifying your employees? How are you notifying your clients if they happen to come on site, or visitors, and all those sort of things? And I think that's the 10,000 foot view. And I will say the same thing that both Andrew and Seth has said, and Kevin, is that this is a constantly changing regulation environment. And the minute we get one piece of information, something else comes out that supersedes it or overrides it.
Kathy, this is Seth. Can I follow up on a great point that you raised?
Sure.
Kathy raised a point that I just wanted to briefly follow up on, which is really particularly important in the government contract space. And the point that she noted was that although the Biden administration is becoming more proactive with regard to more clarifications and federal requirements in terms of how to be able to expect bringing your people into work or having a broader return back to work. One of the points that she mentioned, which was also really important, is that there are various state law requirements that sometimes provide a very patch quilt, inconsistent level of additional regulatory requirements. And in fact, the state level requirements may also be relevant and further beyond to also look at local county requirements. This is something that can be particularly critical in the federal government contract space, because you may have work sites certainly beyond the Washington, D.C. metropolitan area. And to the extent that, let's say you have, for example, people in California, the facts on the ground, the situation, the laws, the local regulations are going to be different. One of the things that I had talked about in the context of vaccinations is whether the employer might have an issue with regard to the vaccination mandate under the negligence standard. And I still believe the answer to that is no. But on a separate but related issue, if there is a return to work or a broadening of a requirement for people to start to return back into the office now that we're getting a vaccination rollout at the rate of nearly 2 million vaccinations a day, it's very important that the government contractor take a look at all the locations where its employees are located, because in order to be able to meet any kind of a potential liability under a negligence analysis, it has to be cognizant of those requirements. So I just wanted to briefly follow up on that point that Kathy raised, because I think it's particularly important.
Thanks, Seth. And to kind of follow up on your follow-up, I think another piece that's really key and very, very, very nuanced is federal versus state, and who, if there's a conflict, who supersedes who. And in the case of government contracting, it gets down to where is your employee sitting and who owns that property. So for example, if your folks are sitting on a San Diego Navy base, that's actually federal property, and federal law supersedes. And so California could have 1,000 regulations that say that you have to have purple hair on Tuesday, and none of them apply to you because you're sitting on federal property. But if you happen to be working for the Department of Labor, contracting for the Department of Labor in a rented office building in San Diego, then guess what? Everything in California now starts to apply to you, because that's not federal property. That's just an office building they're renting like a tenant anybody else. And now it all starts to, rack and stack. So just something else to keep in mind. It really does get down to a lot of if-then questions.
And that goes into what I said some. You've got to make sure that you talk with your lawyer, your HR expert, people who are familiar with not just your environment, but where you have employees. Because if you don't, as Kathy said, rented office versus naval base, you could end up getting caught in a mousetrap there. And that's the last thing you want. It may seem like an unnecessary pain to pick up the phone, call, or pay an HR consultant or a lawyer, but it's one of those small investments that will pay off by nobody filing a complaint against you or you not being fined by the state. It's worth taking the time. It's worth spending the money if necessary to make sure you're in compliance. And with the rules changing so quick, it's not your job to keep up with all of those rules. That's what HR folks do. That is what lawyers do. That's what business consultants do. It's a good idea to reach out and ask for that help.
Kathy, I think California might actually have a law that requires folks to have purple hair. It's being considered. But we have a couple really good questions from the audience here. First one in from Lyndon Renwick, a fellow lawyer and legal scholar. What is an example of a specific and grounded religious objection to the vaccine?
That's a great question. That's by far the narrowest of the narrow exemptions. The only time that I could think of one coming up is there are some religious objections that have been interposed by people who have demonstrated that it is against their religious beliefs to have medical intervention. I cannot recall what faith it is, but I have seen instances in the media of some individuals presenting a specific faith-based objection to medical intervention, including people who are hospitalized. I don't recall if it was the Mennonite community, but that would be an example. But it has to be specific, and it has to be something that would be grounded in that kind of an objection. But that's a great question, and I think that the elements and the situations of that would be few and far between.
Beth, a question for you. So if somebody was moving forward with a religious, objection, what is the burden of proof that the employer needs for that? I mean, are you going to ask for attendance at their church, or I'm just curious about how do you just take it as a face value conversation, or do you need some sort of burden of proof for that?
Yeah, great question. That's a tough one. I think that I don't think it's really an issue of attendance in one's chapel or church. I think it's more, my first step as an HR professional would be to say, can you please send me an email that helps me understand the substantive basis or grounds of your religious objection? In other words, can you tell me what is the nature of the religious objection, and specifically how it will be violated by getting the virus? And I think that there may be a small part of the religious community in America that may be able to articulate that. But I would also predict that there would be a significant portion of people who would not be able to specifically substantiate exactly that position. And with all due respect to the employee, I think that they would have to provide some kind of initial substantiation.
Terrific. Thanks, Seth. Thanks, Kathy. A question in from Lisa Curtin and a follow-up question to this one as well, too. If your employees have been back at work since last May, pre-vaccination, of course, as an employer, can you still require them to now be vaccinated?
Well, I'll start on that one there. First off, if client sites are going to require it, and you are sending employees out to client sites, if that due to the changing environment, it's a new rule that's been promulgated or something along that line, then yes, absolutely you can. And you can push it to it being the client's responsibility. Now, as to whether or not you can, if you've had people in and you've got that inertia built up, the answer I would argue would be yes, because this is a constantly evolving situation. And now that there are better tools available to protect employees from this virus, we as a company are choosing to utilize those.
And in a follow-up question to that, Andrew, I'll pose this to the entire panel. Are there any potential setbacks for employers to financially incentivize employees to be vaccinated? And obviously, in that situation, you're not paying people who don't get vaccinated.
I'd be happy to throw my hat into that first. I think the only potential setback to an incentive plan for a vaccination program is if the employer implements the plan in an unlevel, non-even-handed way. So, for example, if there's any kind of an argument that could be raised by the rank and file that people of a certain protected classification, be it either race, religion, age, what have you, are getting some kind of a preferential treatment, that might be an issue. But I think as long as it's applied in a level, even fashion, I think that the likelihood of liability coming from that would be extremely minimal.
I've also heard, it's just a rumor, so nobody go out and cash the check yet, but I've heard that some of the insurance companies are talking about if you can get to a certain percentage of your staff vaccinated, that they'll talk about credits or discounts on your health insurance to try to prevent future further problems. And in a way, you might be able to then apply those credits back to the employees that were using that particular healthcare or insurance or something else like that, to help cover their additional costs.
Yeah, and to piggyback on that, Kathy, we're waiting to hear some guidance from both the government and the insurance carriers if there are going to be employer-sponsored vaccination programs available as well, too. I would anticipate that might lean toward larger employers, but we don't know yet. But that's something we're watching. We're watching very, very closely here. Another good question in: can a hiring employer lawfully ask an interviewee whether they have received the vaccination, or potentially to decline to hire a person because they are not vaccinated?
I'll be happy to jump in. Sure. I think that they can inquire and respectfully request proof of vaccination. And I think that if somebody wants to hire a candidate and the candidate doesn't have, has not been vaccinated, they would first want to let the person know that, consistent with CDC guidelines, that would be a requirement. And then as long as you maintain a record that was refused, then I believe that that would be a position and an action taken by the company that will be well grounded.
Yeah. Also, I'd like to jump in on that too. I think much like if you're advertising for a cleared professional or you're advertising other job requirements, I think that that's something you can put at the very beginning of the process, especially if it's going to be on a client site that requires vaccinations, must be cleared, must be vaccinated. Put it in your ads, put it in all the material you're putting up out front. just so people have that understanding.
And I think, Andrew, following up on that, something to the verbiage of this job requirement requires you to follow all CDC and federal and state mandated guidelines as it relates to, COVID or something else. That way, if the guidelines are constantly changing like they have been, you don't have to worry about the timing of what you stated in your job posting. It will keep up with the times if you get the verbiage just about right.
Thank you, Kathy. And in follow up to that, this is more of an HR question. Well, potentially a question for the entire panel, so I'll pose it to everyone. But can an employer require a potential employee or existing employees to actually show proof that they have been vaccinated?
Yeah, I think we can go back to Seth's comment there, which is, if you have mandated it for your company, or your client has mandated and your person has to go on site, then it's another box that you're checking, just like security clearance, or if that particular job requires you to be fluent in, Arabic, left-handed, whatever. It's now a official job requirement. So yes, you can require proof, and you're going to want to keep proof. You're going to want to keep proof, though. In your HR files, there's a section for sensitive information, right? This is where you put things that maybe managers can't see or anything else. And this is where you're going to want to keep that sort of proof. You're going to want to keep it away from performance reviews. You're going to want to keep it away from benefit paperwork, because this is PII information and possibly health information, depending on what's on that form. I know I've seen some COVID tests come back. Sometimes there's things like, your information, your height, your weight, your blood type, all sorts of stuff. So whatever is on that form, you want to treat it as if it has PII information and therefore secure it appropriately.
Thanks, Kathy. I'll keep it going along those same lines of HR questions here. Do you want to take a stab, Kathy, at what a scenario would look like if you were to financial incentivize employees? What would a plan look like? Are we talking about giving people Starbucks gift cards here, or a bump in pay?
I would definitely not do a bump in pay, because a bump in pay once given is very hard to take away. And we all know the federal marketplace, if it's one thing, it is never the same day to day. So you don't want to increase costs in your labor in an ongoing fashion that you may not be able to support in the future if you have to get in a highly competitive bid where you have to start slashing costs. Gift cards are a little tricky, because if a payroll person's standing behind me, they're saying it needs to be taxable income, it needs to be taxable income, it needs to be taxable income. So my advice would be either in the form of a bonus, a one-time spot bonus, or in the form, depending upon, again, what happens with the insurance companies. If your healthcare insurance person says, I will give you 10% off every single person that vaccinates on this year's bill, to pass those costs off to the employee and reduce their employee portion of their healthcare costs.
I would just add to Kathy's point, and I think all those suggestions are excellent. There have been reports in the media that companies like Trader Joe's, obviously they're not a government contractor, although we all love Trader Joe's, and a few other companies have provided 2 or 3 hours of paid time off as required to get the virus. And I think the beauty of that is that it's kind of an internally guaranteed way to have it be fair and level, because then I think Kathy raised a great point, maintaining benefits commensurate with salary levels and maintaining those as a constant are certainly a good idea. But if you provide, say, 2 hours worth of paid leave to get the virus, it would just be at the then applicable rate or wage for each particular employee. So that might be another strategy too.
Yeah, and I think, Seth, you're meaning to go get the vaccine, to pay them to go get time to get the vaccine.
I'm sorry, what was that?
I said, I think you were saying to pay them time to go get the vaccine.
Yeah, to paid time off, exactly.
Yeah.
Terrific.
Which brings it to another possibility. You could just, not necessarily give them the paid time off to get the vaccine, but that could be your incentive. You get an extra day of PTO. And the benefit of doing something like that is, rather than having a one-time cash crunch where you got to pay everybody their bonus at the same time, it's something that would be amortized out over the remainder of the year. as people take time off at their own discretion.
Agreed. You just want to make sure that as you look at that, certain states treat PTO as wages and certain states treat PTO as benefits. The difference being, if it's a benefit, you don't have to cash it out if they leave the company. You can take it back at the end of the year if they don't use it. If the state sees it as wages, once given, can't take it away, must pay it out. No problem, but you just want to be aware of that as you do the number crunching in your head.
That's a great distinction. We'll change the topic up a little bit here. Good question from David about foreign travel. In regards to foreign travel, we're talking business trips, not relocation here. This is a necessary part of our business. Are the liability concerns different from working at home or at U.S. office space? Somebody who's traveling abroad for business.
I mean, I'm going to say I think you might have issues, and Seth can probably speak to this. I think the employees, based upon what Biden's saying he's marching to and what the state's saying they're marching to, might be able to refuse the trip if they feel that it puts them at risk health-wise, and you may not be able to do anything about it. I don't know, Seth, what's your opinion on it?
Yeah, I think that's a good point. It's just so amazing how the COVID environment changes literally week by week and sometimes day by day. Have different variants that are getting sourced from different countries in different parts of the world that may have a higher rate of transmission and may have, a more impactful medical result on someone when they incur that. So I think that part of the analysis to that would have to involve asking what country we're talking about. Is there an outbreak of a different variant? Has the Biden administration imposed travel restrictions? There are new restrictions on travel where if you go to certain parts of the globe, there are restrictions in terms of your ability to be able to make it back without carrying with you, immediate timely proof that you're fully vaccinated. So I think the United States laws would be the constant in that analysis, but it would really depend on where people go. But I think that's another example of how COVID continues to throw new curveballs over the plate every day. And that even if you plan a trip to South Africa 7 days from now, what's going to happen in day 5? Is there going to be a new outbreak of a virus? So I hate to use the lawyerly answer of it depends, but it does in a sense. But the overall texture of the laws here in the analysis would stay the same. It really just be dependent upon the time frame and the geographic location of what the travel is involved.
Thanks, Seth. And I would say that I've had several clients successfully approach their contracting officer when travel abroad was still required and negotiate ahead of time that when that employee comes back and has to do 2 weeks of quarantine, and or if that employee ends up getting sick within 2 weeks of coming back, that all that time is billable back to that contract and engagement because they had created the requirement and risk. So I would say it would definitely be a conversation I would have with your contracting officer before the first person leaves so that you understand the liability you're taking, either billable or not billable, indirect costs versus direct costs.
It's a great point.
Excellent. No, thank you. Question in from Lisa Curtin, and this is a question asked by a couple of different people here. If one staff member is tested positive, is it lawful to ask all staff to get tested and to share the results with HR before they're allowed to return back to work?
Well, I'd be happy to go first. That's another tough one, right? I think that if the employer is able to confirm in terms of proximity and duration that under the CDC guidelines, there are certain people within proximity in the office who may have been in meaningful contact with that person, and provided that it's focused on that group, the employer may require those individuals to go ahead and get tested. So as long as it's focused and specific in scope, yes. Can they then require the employee to feed back to HR what the result of that test is? Yes. Can they then share that broadly with regard to the medical information that comes in as a result of that medical feedback? No.
Terrific. No, thanks, Seth. Good answer. Kathy, question for you posed by Claire Love. And this deals with the preparedness plans. Are the preparedness plans being discussed required only for on-site employees, or do you have to have specific preparedness plans for people who are working from home?
So the preparedness plan is for when they would go back, right? So you don't, like, this is constantly evolving. So you need to have a preparedness plan in place as it relates to if and when your employees come back to the office. So no, you don't have to have a plan if you have people in somebody in Arlington and somebody in Alexandria and somebody in DC and somebody someplace else. But what you do have to do is if you have an office in Maryland and an office in DC, and I think it might be frozen, that you have a plan for each one of those office spaces.
Sounds good. Thank you. Another good question here. What happens to an employee or worker that you want back at the office and they are perfectly healthy, but they have a spouse or a child who is vulnerable? Can they be forced to come back in?
These are all really tough questions. We definitely invited people in who have the toughest questions of the day and the smartest questions of the day. I think that let's think about that. If the person has a compromised immune system, but they don't presently have a disability, then it wouldn't be a family medical leave act situation if the spouse is healthy. But if the spouse has a compromised immune system and the spouse is concerned of coming into work in terms of a transmission risk when he or she goes home at night, I think that a short-term reasonable accommodation request would be for the employee to ask for a short period of time to be able to confirm the status of the staff's vaccinations. So I think in the short term, I think that would be a reasonable request. But I don't think in the long term that would hold water, because at some point it is a reasonable requirement for the requirement of the person to be able to return back to work if that is a part of the essential functions of performing the job.
Yeah, I would also say part of the burden on it does have to be on the employee. What if one of the kids came home with the coronavirus? What would that employee do? How would they sequester things? Because if you take this too far and too far and too far, I have dinner with my dad a couple of times a week. He's 94 years old. So, Kevin, I'm sorry, I'm not coming into work anymore. That's at what point does the company have the right to draw a line and say that, yes, you're coming in, figure it out on your own? Because companies absolutely have responsibilities to take into account the disabilities of their employees under the ADA, as Seth described. But a company doesn't have the obligation to take on the disabilities of everybody in that person's sphere.
That's a great point.
Kind of along those same lines, what happens if you have an employee who doesn't have a valid exemption for not getting the vaccine, but is just plain old scared? I've heard on the news, fill in the blank, I'm afraid to get the vaccine. How do you handle that?
I mean, if you're going to put a policy in place that says a vaccine is required to return to work, or your client puts a process in place that says the vaccine is required to return to work, and the work can only be done in person, then they basically sign their resignation.
Yeah, I mean, one of the and ultimately, I think unfortunately that would perhaps need to be the conclusion. What I've told some of my clients is have one or two layers of information in reserve available to be able to share proactively with the objecting employee. So, for example, have a report from the CDC in your PDF file that explains that the Pfizer and Moderna vaccines are safe and effective, and then be able to have something that you can click out to somebody within 2 minutes that says, I hear you, heard, understood, but unfortunately, it's a requirement for return to work. Let me share this with you. This is a report from the CDC. Be ready to share information to be able to address them. But I do agree that ultimately, if they don't follow it and they still say no, and companies are really being pressed to the limit on this, there's going to be an end to that point at some juncture in time.
And I do know that different vaccines, based on how they're made or what they're brought into, can be different for different people. So, for example, I know that the Johnson & Johnson vaccine that's coming out is the one being recommended for people that are currently in breast cancer treatment or breast cancer survivors. And they're recommending that they don't take the first 2 vaccines. So some of that can also come into play, that, it may be the specific vaccine in its place, and the next one may be the one that works for them.
Terrific. Well, thank you, everyone. We're at the top of the hour. That 60 minutes went by fast. I'd like to thank the audience for great questions today. And I'd like to thank our panel of experts as well for carving time out of their busy days to talk this topic through. I'm sure there'll be more questions to come in the weeks and months ahead. We're going to revisit this topic again once the landscape becomes a little bit more clear. But if you have any questions in the meantime, please don't hesitate to reach out. But everybody, enjoy the snow today, be safe, and we'll talk again soon. Thank you all for attending.